As mentioned in the LA Times article, advocacy groups are stepping forward to file amicus curiae briefs in defense of California Civil Code 47.1 and AB 933 after Justin Baldoni's legal team tried to argue against its constitutionality in their response to Blake Lively's motion to dismiss his defamation suit against her. As of this video, 19 individuals and organizations have signed their names to 4 separate briefs. I've covered the first 2 briefs, and in this video, I will be going over some points of the third one, submitted by the organization Child USA. This coverage won't be super extensive because I don't plan to go into detail about anything already mentioned in the first 2 briefs. You can check out my videos on those in my Baldoni Baloney playlist. But the motion letter to submit this brief and the brief itself seem like a direct response to the legal argument presented by attorney Brian Friedman and his team. I've been seeing some people parroting Friedman's claim that this law is unconstitutional, usually because they don't understand how the law itself works, what rights are covered under the First Amendment, or the larger social context that brought about AB 933's enactment. While many pro Baldoni people probably aren't watching my videos, I do want to provide those on Lively's side with the tools with which to combat the rampant spread of misinformation sourced from Brian Friedman. If you are pro Baldoni but would like to be more educated on this law from a legal perspective, you might still find this video helpful. I also think that it's a good idea to read over this brief itself. I already went over why Friedman's opposition to amicus briefs being accepted by the court for this case doesn't make logical sense, but the Child USA motion to submit their amicus brief clarifies how ridiculous his opposition is within the context of routine court proceedings. First, there is no applicable rule of civil procedure governing amicus curiae briefs, so district courts have broad discretion to permit or deny an appearance of an amicus curiae in a case. In fact, it's not unusual to submit such briefs as courts have accepted amicus briefs were helpful to ensure that the court receives a complete and plenary presentation of difficult issues so that the court may reach a proper decision. Child USA adds that courts will generally err on the side of granting leave because if the court finds the brief unhelpful in its evaluation of the underlying motion, the court can simply disregard the amicus brief. Further, Friedman's claim that additional argument about the abuse of the discovery process from the first amicus brief filed by the ERA, CWLC, and CELA should not be considered because it was not mentioned by Lively in her MTD is meaningless, as the filing of amicus briefs should be permitted if it will assist the judge by presenting ideas, arguments, theories, insights, facts, or data that are not to be found in the parties' briefs. Similar to the other 2 amicus briefs I've gone over before, Child USA outlines factual statistics and details about the rates of sexual violence and the culture of silence that surrounds this issue. They argue that retaliatory defamation lawsuits contribute to that culture. But the part I really wanted to get into today is their argument for the legitimacy of California Civil Code 47.1 and AB 933. First, they explain why retaliatory defamation lawsuits are filed, setting the groundwork to then explain how this law weeds out these lawsuits and only punishes offenders for abuse of the court system. Next, they clarify what the First Amendment covers and what it doesn't, making a case for how California Civil Code 47.1 actually bolsters the protections of the First Amendment and does not undermine it. Finally, they stress the relevance of this type of legislation during a time of social reform brought about by the Me Too movement. To summarize what all 3 amicus briefs so far have presented, since the Me Too movement, rates have risen in defamatory lawsuits to silence survivors who speak out about their experiences. This particular type of retaliatory lawsuit is intended as punishment for those daring to speak out through an invasive discovery process and costly litigation. The fear that one might not be able to handle the financial burden is part of what keeps victims silent. The chilling effect of retaliatory lawsuits is not hypothetical. It is well documented and was explicitly recognized by California legislature. The Assembly Judiciary Committee noted that such lawsuits bully the defendant into silence and intimidate those who might speak out, undermining both access to justice and public safety. With that in mind, the law itself is a narrowly tailored legislative measure that protects survivor speech and deters the misuse of defamation law. That means that defamation lawsuits with a basis to the claim are able to get through even with this law in place. The law itself intends only to prevent their misuse by imposing consequences on those who use the legal system to retaliate against protected expression. Let's get into the full explanation. Since retaliatory defamation lawsuit claims are pled with the intent to intimidate those who might speak out, they are not protected petitioning under the First Amendment. That's because these lawsuits lack credible evidence of falsity, malice, or actual harm and are filed despite corroboration from witnesses, internal investigations, or contemporaneous reports. This abusive legislation tactic falls outside Nora Pennington's scope. As California Civil Code 47.1 targets only meritless lawsuits aimed at chilling protected expression and imposes no civil liability for good faith claims, when a retaliatory defamation lawsuit is dismissed on grounds that it does not have a strong enough factual or legal basis to support it, it makes sense that the party that creates the cost must bear them, which is why the fee shifting provision is valid as a means of helping victims cover the cost of fighting this sham litigation. Child USA reminds the court that these remedies are not prior restraints, nor do they bar plaintiffs from accessing the courts. They simply deter the misuse of legal processes as a tool of harassment, meaning that defamation lawsuits may still be filed by anyone, but if offenders are aware that they cannot get very far with their plans to harm their victims financially and emotionally, they may think twice about using defamation lawsuits as a means to do that, especially if there's also the risk that they might also suffer a financial cost. The brief goes on to argue that California Civil Code 47.1 advances core First Amendment values and serves compelling state interests. With regards to litigation, the First Amendment interests are strongest when the suit raises a genuine grievance. The right to petition the government for redress of grievances is not absolute because not every petition has merit, as in the case of retaliatory defamation lawsuits. They contrast this with survival disclosures, which fall squarely within the category of speech entitled to heightened First Amendment protection, because these disclosures serve essential public functions, exposing misconduct, prompting institutional reform, and preventing future harm. We can see through how the Me Too movement was developed that a single survivor disclosure may catalyze waves of additional reports leading to institutional reckoning and widespread reform. California Civil Code 47.1 is narrowly tailored to achieve these aims and is content neutral. It protects a category of speech, factual, non malicious disclosures of sexual violence, without regard to viewpoint or ideological perspective. Child USA makes it a point to mention that California Civil Code 47.1 is part of a growing national movement to enact speech protective laws that guard against forms of legal intimidation aimed at silencing survivors and to increase meaningful access to justice. They discuss various states who are enacting or proposing similar legislation, including Oregon's General Assembly introducing Senate Bill 180, New Hampshire's introducing House Bill 580, and New York's Civil Rights Law 76-A. Similar bills have been introduced in New Mexico, Wisconsin, and other states. These legislative reforms are united by a common policy rationale: dismantling the legal and structural barriers that have historically silenced survivors and shielded perpetrators from accountability. So, to summarize, California Civil Code 47.1 is not a violation of the First Amendment, but was written with the intent to bolster the right for victims and survivors to disclose their stories without fear of retaliation. Survivor stories do a public service in advancing the fight against sexual violence. The fee shifting provision, including treble damages, is necessary as a means to compensate survivors who speak out and are targeted by meritless retaliatory defamation suits. Whether or not you are Team Lively or Team Baldoni, consider this law on neutral terms and remember that an argument against its constitutionality doesn't only harm her, but would work towards silencing all survivors. Is it worth it for you to undermine this protection of all survivors' rights to destroy one woman that you think is lying? As usual, I've got links to the briefs in the descriptions, and I will be in the Baldoni Files subreddit and on Blue Sky discussing this case. I don't make videos about every single document that's filed, but I want to continue with this series on AB 933 and the Amicus briefs because this case has always been about more than just Justin Baldoni and Blake Lively to me. It is a case that puts a spotlight on our culture of sexual violence and misogyny, and it will have an impact on what's to come for other survivors who wish to speak out.